Hey everybody, I'm Paul Rabley, and in this video we're going to talk about the mechanics and the advantages of gift splitting. So I'm Paul Rabley, I'm an estate planning attorney. I help our clients get and keep their estate legal affairs in order. Best way to go over this topic is to give you an example. So let's say we'll call him David the donor. He's a husband. David the donor wants to give $30,000 to his son named Fortunate Phillip. The $30,000 that he wants to give Fortunate Phillip is David's separate property. Maybe it was an inherited asset that David had. Maybe it was an asset that was given to David. Or maybe David and his wife, we'll call her consenting Claire. Maybe David and Claire have a prenup, so they have nothing together. They have no community property. Everything they have is separate. And David wants to give $30,000 of his assets to his son, Fortunate Phillip. But he does, and maybe he wants to give. Maybe he just wants to write a check to Phillip. Maybe he wants to give stock to Phillip, or maybe he wants to give a partial or fractional interest in a piece of land or a business to Phillip. Nonetheless, that gift has $30,000 of value. But David the donor doesn't want to use any of his estate tax exemption. He wants to preserve all of that. And maybe David wants to do this $30,000 every year. And maybe David wants to give $30,000 to a whole bunch of people every year. But again, he doesn't want to use that estate tax exemption, which he'd be using if he gave someone more than $15,000. All right, so what does he do? Well, there's a concept called gift splitting. And this is not our example, but let's say David and his wife wanted to give $30,000 and they were going to give community property to Fortunate Phillip. Well, if they're going to give community property $30,000 to Fortunate Phillip, then the community property is considered to be made one half, that gift of community property is considered to be made one half by each spouse. So it's a $30,000 gift of community property, considered to be made half or $15,000 by David and half $15,000 by consenting Claire. But David's not given community property. He wants to give away his separate property. Okay, so what does he need to do to avoid using up any of his estate tax exemption? He needs to do something like go to his wife. David needs to go to his wife, I'll call her consenting Claire, and say, look, Claire, I want to give some of my money to my son. I want to give him $30,000, but I don't want to use any of my estate tax exemption. I want to preserve it. But however, consenting Claire, if I file a gift tax return and you sign the form consenting to having those gifts considered as being made by one half by each of them, then under the tax rules, those gifts will be considered to have been made one half by David, one half by Claire, and David won't use any of his estate tax exemption. In theory, Claire's saying, okay, husband David, you make the gift of $30,000 and I'll let you use my $15,000 present interest annual exclusion so that gift of $30,000 avoids either of us using up any of our estate tax exemption. I can't really think of any reason why Claire wouldn't do that. So what they do is he makes the gift of $30,000 to Phillip, and again, maybe he does it to many different people, and maybe he does it every year. But now David, because he gave separate property and he needs Claire to consent to allow David to use Claire's $15,000 present interest annual exclusion, David's got to file a gift tax return, which I have right here. It's called Form 709. And on that form, on page 1, there is a place where consenting Claire will sign that says, I consent. It's called, in bold letters, it says consent of spouse. I consent to have the gifts made by me and by my spouse to third parties during the calendar year considered as made 1/2 by each of us. It's a little bit more than that, but then consenting Claire signs and dates it. So even though nobody's using any of their estate tax exemption, when there's this gift splitting, which includes a consent by a spouse to allow a $30,000 gift to be made without the husband using any of his estate tax exemption, still got to file the returns, still got to sign the consent, but that's the way that Dave the donor can give more of his property without using any of his estate tax exemption. So that's a kind of gift splitting, and it's really which includes the consent by the spouse. So bottom line there, if a couple is giving community property, it's considered to be made 1/2 by each. If they're not giving community property, and here in Louisiana where I am, we're in a community property state. There's 8 or 9 community property states. But when here in Louisiana, when a spouse donates separate property, then if that spouse wants to avoid using his or her estate tax exemption, the spouse can only give $15,000. However, if their spouse consents to split the gift, then the spouse can give $30,000 of separate property without using any of the estate tax exemption. So hope that clears some things up on gift splitting and a spouse consenting to allowing gifts made by either one of them to be split so that it's considered to have been made 1/2 by each. A lot of stuff there, but it's an issue that came up today, and so we had to deal with it, and thought I'd pass the information along. Hope you're kind of soaking in some of this information. If you have some questions that you'd like to see addressed on a future video, type them down in the comments below. Always great to see people subscribe on the subscribe button that you hit, and then click the notification bell so YouTube will keep you posted as we make further educational videos. And then if you can give us a thumbs up with a like, that would be great. I'm Paul Rabelais. Have a great day.